May it please the court. My name is Radzivilovskiy, and I represent the petitioner. The issue in this case is whether the Women's Right to Know Act that imposes obstacles far greater than those accepted by any prior decision for a woman to get an abortion places an undue burden on the woman and is therefore unconstitutional. Louisiana passed WRK, which requires that an abortion provider give certain information to women seeking an abortion, including a mandatory ultrasound that costs $100, and then requires a 36-hour waiting period to get an abortion. Most people in southern Louisiana live below the poverty line. Almost a third of the population lives more than 100 miles from the only abortion clinic in the state. Jay perfectly illustrates one of these people. She lives below the poverty line, 200 miles away. When Jay found out that she was pregnant, she decided to seek an abortion. She took a 4.5-hour bus ride to the clinic and was met by a group of angry protesters. After being provided the information and consent materials, Jay had to wait 36 hours. Up to 12 weeks, an abortion is $325. After, it increases by $100 each week. Medicaid does not even pay for abortions in Louisiana. After the 14th week, the clinic does not perform an abortion. Because of the heavy burden that WRK placed on Jay in getting an abortion, it forced her to obtain an illegal abortion, which led to life-threatening complications. In fundamental rights cases, the court uses strict scrutiny, which requires a compelling state interest and a narrowly tailored law. In Roe v. Wade, the court held that the right to privacy it had found in Griswold protects the woman's right to choose to terminate her pregnancy. The court in Casey set forth the undue burden test, which examines whether there are substantial obstacles placed on the woman to get an abortion. This law particularly burdens women who live in rural Louisiana. A substantial amount of them would have to travel over 100 miles. For a woman like Jay, the clinic is sometimes 200 miles away. The law also requires a 36-hour waiting period, which in practice is really 2 days because a clinic is likely closed 36 hours after any appointment. This will create two problems. First, women would have to take 2 separate trips to the clinic. And second, women in their 13th week it would be for them impossible to get an abortion at all. The 7th Circuit in Carlin said that while a 24-hour waiting period that requires 2 trips to an abortion provider did not impose an undue burden in Pennsylvania, a similar statute in another case could impose an undue burden. And here, the waiting period is nearly 2 days. Also, WRK requires that information be provided to women before they can obtain an abortion. In Casey, the court said that the information provided cannot be misleading. There, the law required an abortion provider to inform the woman about the availability of information. Here, they're required to give certain information, including the age of the unborn baby, health risks to the mother, and the fact the child will experience pain. Some of this information is contested by scientists and may be misleading. Moreover, women have to sign a consent form stating that the abortion will terminate the life of a whole, unique, living human being. The state is determining itself that the fetus at this stage is already viable, and the use of the word terminate essentially means to murder. All this information seems designed to make abortion as psychologically damaging as possible. This is not helped by the fact that these women face angry protesters when they go to clinics. Here, the many requirements and hurdles that the law creates make it clear that, as in the Sundquist case, the law is intended as an obstacle to abortion. As the court said in Casey, if an undue burden exists, this law is invalid because it serves only an impermissible purpose. That's exactly what WRK does here. In conclusion, Your Honors, putting too much burden on abortions does not stop them from happening. Like Jay, women will still get abortions. Now they will be much more dangerous. Thus, Your Honors, I ask that you decide that WRK is unconstitutional and that you overturn it.
Good evening. May it please the court, opposing counsel. My name is Fabian Small and I represent the respondent. The issue in this case is whether the Women's Right to Know Act creates a substantial burden to a woman's right to terminate her pregnancy under the Due Process Clause of the 14th Amendment. In the present case, we have the story of Jay, a young college-bound student who became pregnant, and rather than upset her life plans of higher education and beyond, she decided to have an abortion. After going to the state hospital at 12 weeks pregnant, Jay was informed of the emotional and monetary cost of having an abortion. Instead of following the process the Women's Right to Know Act provides, Jay went to have an abortion done illegally, from which she suffered medical complications. The WRK Act, recently passed by Governor Chuckabee, serves an important interest. The Louisiana Department of Health recently released statistics that the number of abortions performed in the state increased by a resounding 10% in just the last year. Analyzing these numbers in light of reports that women may suffer psychological damage after an abortion, Chuckabee declared that the state has a legitimate interest in reducing the risk that women may have abortions without being fully informed. The WRK Act mandates that a woman seeking an abortion listen to an information session and wait 36 hours before having the procedure. She must also learn the age of the unborn baby and have an ultrasound. The NSC filed a lawsuit on behalf of women stating that Jay's story is evidence that the WRK is unconstitutional. However, Your Honors, this is in fact wrong. The WRK Act does not create a substantial obstacle to a woman's right to terminate her pregnancy. Roe versus Wade declared the decision to become a parent is fundamental, yet not absolute. The opinion recognized that the state has a valid interest in safeguarding maternal health and protecting potential life. The Casey decision distinguished that a state regulation on abortion is unconstitutional when its purpose or effect is to place a substantial obstacle in place of a woman seeking an abortion before the fetus attains viability, as evidenced by the undue burden test. Here, the compelling purpose behind WRK is to protect the well-being of women that are unaware of serious psychological effects that they may deal with after having an abortion. The Casey opinion goes on to support that, although women have the right to choose to terminate or continue their pregnancy before viability, it does not at all follow that the state is prohibited from taking steps to ensure that this choice is both informed and thoughtful. Essentially, the WRK is trying to provide enough information to these possibly underinformed women about how such a decision could negatively affect their lives. The petitioners may argue that women of lower income are disproportionately burdened by the statute because of added traveling and costs. However, the facts demonstrate that these arguments are unfounded. Petitioners think the 36-hour waiting period is a burden because of extra travel costs and stress. The court has found minimal wait periods are appropriate and constitutional. The Casey opinion held that a waiting period of 24 hours is tolerable, while Sundquist overruled a full 2-day waiting period for being overextensive. We contend that the WRK not only mandates for a short waiting period, it also provides women a time to contemplate the information they've received, in an attempt to prevent the depression that often follows this procedure. Also, there's an exception when waiting is dangerous to the mother's health. Furthermore, travel is not an undue burden for the women of Louisiana. Force considered the burden placed on rural women who don't have access and ruled that the affected women was not significant enough to be an undue burden. Here, the population is within a 100-mile radius, and therefore public transportation to the center of town is very possible and even convenient. Petitioners think that the information session and mandatory ultrasound is a burden because of the cost of the procedure and potential guilt. The Casey opinion found info sessions to be constitutional, and moreover, informed consent is standard practice in most medical procedures. The info session is just a tool to help women understand the procedure and its side effects, which will reduce potential psychological harm as opposed to causing it. Also, the statute provides exception for women who do not wish to see the ultrasound, which is only an extra $100. This may seem steep to some, but certainly not overwhelming, Your Honors. As part of good policy, the WRK should be upheld. Its main purpose is to make sure that women are informed to mitigate psychological harm that occurs from not knowing. Furthermore, the waiting period allows women an opportunity to make the best decision in light of the information provided, which will mitigate any further unnecessary trauma. Your Honors, we the respondents ask that you rule in favor of the Women's Right to Know Act and find this ordinance constitutional. Thank you.
Petitioners cross and begin.
Opposing counsel. In Casey, the court recognized that the woman's interest in reproductive freedom outweighs the state's interest in regulating abortion before 12 weeks. Isn't allowing the state to conclude that the fetus is viable at conception simply backdooring the holding in Casey by essentially saying that the fetus is viable at conception?
Well, no, Counselor, I would have to respectfully disagree with you, because essentially the state is only trying to make sure that they have the women, all women, under the provision of the Women's Right to Know Act, are fully informed, and that they have a deliberate decision, make deliberate decisions in trying to figure out whether or not they want an abortion.
But isn't there a difference, Your Counselor, in requiring that there be accessibility to information than here, where it's clearly tailoring the information to just for women not be able to get abortions? Because in the consent form, it clearly says that the woman has to sign that she will terminate the life of a unique living human being. And there would be a lot of women who want to get an abortion before 12 weeks. And in Casey, it said that at this point, that it rules into the woman's favor. So isn't this essentially a very misleading law?
Well, Counselor, I also disagree with the fact that it's a misleading law. One, for the fact you said that the women are inaccessible to the center of town. Essentially, it's within a 100-mile radius, and as stated before, it's very possible to take public transportation, which makes it very convenient for the women to achieve going to the center. Yes.
Well, Your Counselor, I'm not talking about the distance.
I think you only have like 4 seconds left. So.
Respondents cross.
Sure.
Well, Petitioner, if you were diagnosed with an illness and you visited the doctor's office, wouldn't you want to be informed of all the information concerning your illness? Yes or no, Counselor?
Yes, but the problem in this case is that the information is clearly misleading. In the question that I asked before, I wasn't talking about the cost of the trip, which I think is a burden for women who live below the poverty line, but I was clearly referring to the exact language of the law,
okay,
which requires a consent form. And in the consent form, it says they are terminating a life of a unique living human being. And the information they're providing, such as, saying that, that the mother, this potentially poses health risks to the mother, that the baby will experience pain.
Thank you, Counselor.
This is information that is contested by scientists and may be misleading.
Thank you, Counselor. And as you stated, you said yes. So therefore, wouldn't you want a woman to be who's undergoing an invasive procedure, to be fully informed of the things that will be happening to them, Counselor? Essentially, if a woman is going to partake in such a serious occurrence, such as an abortion, and it's very invasive, wouldn't you want to know of all the things that are going to possibly happen to you?
Yes, Counselor, and I think I would agree with that completely. And I think this is exactly the problem that is in this case, because in this case, they're not giving all the sides of the story. The law is clearly presenting only one side, saying the health risks to the mother, saying that the child will experience pain. These are facts that are contested by many scientists. And again, the law is essentially saying that she's a murderer and that the fetus is already viable, while in Casey, it said that up to 12 weeks the fetus is not viable, and the compelling interest falls in favor of the mother.
Well, Counselor, you stated that the information was misleading, but if it's in plain view that it says that some experts support the fact that the fetus attains pain.
All right, judges, we're going to start our 6-minute open question.
Respondent, while I would agree that informed consent is a positive thing in any medical procedure, why in this case is it appropriate for the legislature to determine the scope and the information of the informed consent rather than the American Medical Association, for instance?
Well, as supported by the Casey decision, which this court decided on, it stated that the state has a legitimate interest in reducing the risk that women may have an abortion without being fully informed, and essentially that's what the WRK ordinance is trying to do here. We're trying to fully inform these women so that they make a deliberate decision and so that they know exactly what's going to happen to them. It's possible, as stated before, that they may suffer from psychological harm, and we want to avoid these occurrences, and therefore, as I said before, we're trying to fully inform these women.
Petitioner, you stated earlier that you thought the WRK Act is unconstitutional. That was the basis of your argument. What would you change if you were a member of the legislature? What would you change to make the WRK Act constitutional?
First of all, I think what I would change is the information that it provides. Because, in Casey, it clearly said they want an availability, an array of information provided to the woman. I would make sure to, pose several sides to the story and not only tailor it to one specific side. Second of all, I would change the consent form, which essentially says that she is terminating or, murdering this baby, which is viable, to just say that I understand, that this procedure may pose several risks, and I agree. Thirdly, I would change the waiting period, because 36 hours is really 2 days. I mean, after any appointment, when you come in, 36 hours would be the next day, and the clinic is probably, not open. Well, there's no evidence that it's open the entire night. So I think that I would have to change several of those factors to make sure that the law is permissible. Because for now, I think it clearly serves an impermissible interest.
Respondent, isn't it true that many scientists disagree, as Petitioner brought up, that post-abortion syndrome is a real syndrome? And is it really valid for the state to pass out information on this?
Yes, while we do concede that some scientists do disagree with the statement that the fetus feels pain, but there are also scientists who do agree with it. And also, as evidenced in the Sundquist case, it said that women are very capable beings, and they are smart enough to know what goes on, and since they have to read a brochure, it would be smart for them to then ask a follow-up question of a medical practitioner, saying, fully acquiring all the knowledge as to what happens with the fetus.
Petitioner, in your argument, you said that WRK poses an obstacle to abortions, and then you pointed to the angry protesters that Jay encountered. WRK says addresses waiting period and informed consent. What does that have to do with her running into angry protesters at the abortion clinic?
I think, one of the factors for analysis in reviewing the undue burden standard is, the psychological damage that this woman can experience. And I think, traveling all this far, and essentially if it's 5 hours forward and 5 hours backward, and all, it's going to be a total of 20 hours of traveling, which is costly. And when she gets to the only clinic in Red Baton, she's nervous, she spent a lot of money, and then, there's a group of a lot of, angry protesters there, and it just adds to that kind of psychological damage that this woman might have. Now, I would also like to make a further argument and say that, the law could also be changed. Instead of, instead of all the information coming from the provider, it could come from, other places like a school nurse or a local physician. And in Jay's case, she talked about the risks with the nurse.
So how would you change WRK so she didn't run into the protesters? Or you're not saying that you can change WRK to avoid protesters?
On that specific question, I think, that there might be protesters, at several clinics. But I think, if you just change, WRK and, its consent form, I think it, or, the information that it provides, I think generally it just might reduce some of that psychological damage that the woman might have. Now, I agree with you that, it may not limit, the protests necessarily.
Respondent, would you agree that one of the apparent purposes of this law is to reduce the number of abortions? And if so, isn't that, by definition, placing undue burden on the ability, on the right of women to get an abortion?
Yes, Your Honor, I do agree that it's trying to reduce the number of abortions because, as stated before, the state of Louisiana had a 10% increase in 1 year of abortions. But I would like to say that it is not a substantial obstacle. This court, as I stated before, decided in the Casey decision that it was reasonable for some amount of, or a slight burden to be held by some of the women, but essentially it is not unreasonable for a slight burden to be held, and therefore the WRK Act is trying to make sure that these women are fully informed, and this does not create a large enough burden in order for it to be unconstitutional.
Thank you, counselors.
Thank you, Your Honor.
Coach, why don't you come on down? Where you at? I need to learn how to read. My bad. All right. Here we go. Here you go, sir. Congratulations.
Woo!